Good evening, and welcome to the Public Safety and Government Operations Committee meeting. In attendance today, we have President Nick Mosby. We have myself representing the 4th District, Councilman Burnett representing the 8th District, Councilman Cohen representing the 1st District, Councilman Costello representing the 11th District,
Mr. Chair.
Councilman Glover representing the 13th District,
Thank you, Mr. Chair.
Councilwoman Porter representing the 10th District, and Councilwoman Ramos representing the 14th District. And Councilman Stokes representing the 12th District. This evening, the committee will have a hearing on legislative oversight 23-0033, local control of the Baltimore Police Department, for the purpose of reviewing the legislation currently before the Local Control Board in Annapolis to allow community response, and to provide a general overview of the process and procedure that the board plans to move forward with regarding implementation of the above-mentioned legislation. This bill was sponsored by myself, and tonight is the committee's second hearing on local control in the Baltimore City Police Department. After several delegation and General Assembly committee hearings over the last few weeks, it appears that the administration and the City Council have been on different pages. I called this hearing tonight to find out how we can get to the same page about restoring local control and delivering the will of the people and the will of Baltimore citizens as expressed in question 8 last November. There has been a significant amount of back and forth about who has control right now. We've been told that no one has legislative power, and then told that the state may have legislative power, and then been told that the City Council may have either unfettered or limited power. So clearly we need some clarity on this matter. And as deadlines to get bills passed in Annapolis this year rapidly approach, this has been a very confusing process for citizens of Baltimore to watch, and they're justified in asking for greater understanding of who has control now and what must be done to regain full control for the city of Baltimore. Both legal opinions that I've reviewed to date have recommended the removal of language in Article 2, Section 27, that would seem to constrain the City Council in writing laws about broad parts of the department and its operations. And both admit that keeping such language could open up the city laws that the City Council passes to legal challenges. After conversations with the administration has proposed an amendment in hopes of finding compromise. Tonight we'll have an opportunity to discuss that amendment in order to provide both the committee the opportunity to understand the amendment and to provide full transparency to the residents that with 82% of the vote overwhelmingly supported a ballot measure establishing local control of the police department. We'll provide an opportunity for testimony after we hear from our agencies, and without further ado, I'll turn it over to Director Moore to talk through the amendment. Director Moore.
Good evening. My name is Dana Peterson Moore. I'm the Director of the Office of Equity and Civil Rights. Tonight I'm here wearing a different hat, and that is Chair of the Local Control Advisory Board. Our co-chair, Mrs. Shia Parker, is not able to be here tonight. There are a number of members of the Local Control Advisory Board who are here tonight, including Mr. President of the City Council, Mr. President Nick Mosby. And I'm sure that the others who are here who do decide to speak will introduce themselves and their particular constituency that they bring to this floor tonight. I would like to defer to Ms. Nina Themelis to talk about the amendment as it now stands.
Good evening, Mr. Chair, members of the committee. Nina Themelis, Interim Director of Government Relations for the Mayor's Office. So the amendment that I believe we were going to have projected, or no?
You will, yes, there it goes.
Okay. You'll recognize some of this language as reminiscent of what we have proposed to our Senate and House delegations. We are looking to not necessarily remove the last sentence of Section 27 of Article 2, but to add on to it to more narrowly focus the powers of the police commissioner onto those items that we believe should remain under the power of the police commissioner. And then we would continue to agree with the June 1st, 2023 enactment date, but the additional language that's been added based upon the last time that we've publicly discussed this amendment is that after an additional ballot measure were to pass that would actually codify the police department formally, because as you know, In the city charter right now, the police department is only codified in a single sentence, unlike all of our surrounding jurisdictions, or many of them, at the municipal and county level. They have much more extensive language in their city charters or their county charters. So we wanted to make sure that we were on the same page as those other jurisdictions in the way that we codified our police department. So that additional section, which is section 3, and I do want to just mention that this language is not finalized, it's still in drafting, but this is the language that we have shared with the drafters, that once the charter amendment passes, where the language is codified in the Baltimore City Charter, the last sentence of that section 27 would be removed, which would reflect what the will of the initially introduced legislation in Annapolis has been.
Do you mind just reading this piece? I know that it's quite a bit, but I know I was able to send out the amendment to council members just in advance of the council meeting, but I wouldn't be surprised if many of them have not had the opportunity to review the language.
Sure, and when you say this piece, do you mean the entirety of the amendment or just the section that kind of adds on to the previously discussed changes?
I will, because I know not every council member has sort of been on this long ride. It would help if you could at least start at section 27.
Sure, so this again is adding on to Senate Bill 758. Section 27. So Section 27, as it currently reads, says to have and exercise within the limits of Baltimore City all the power commonly known as the police power to the same extent as the state has or could exercise that power within the limits of Baltimore City, provided, however, that no ordinance of the city or act of any municipal officer other than an act of the mayor pursuant to Article 4 of this charter shall conflict, impede, obstruct, hinder, or interfere with the powers of the police commissioner. That was what previously existed. We have added language to, again, more narrowly focus the powers of the police commissioner that would be outside of the council's jurisdiction, to including only those items that are over any daily management decisions, including personnel or staffing matters, and deployment or investigative strategies. And then the additional language that we added is in Section 3, and that is, and be it further enacted that contingent upon the passage of an amendment to the Charter of Baltimore City that defines the police department and the powers of the police commissioner in respect to daily management decisions, including personnel or staffing matters, and deployment or investigative strategies, and any other items as deemed necessary under the Code of Public Local Laws for Baltimore City. Section 27 of Article 2 of the Baltimore City Charter shall read, and then it is just the section without the addition, to have and exercise within the limits of Baltimore City all the power commonly known as the police power to the same extent as the state has or could exercise that power within the limits of Baltimore City, and then with no further action required by the General Assembly, because I knew that based upon the responses that we heard from the advocacy community, nobody wanted to have to go back to the General Assembly again, and we wanted to make sure that that power was locally vested within the population of the city.
Okay, and then I think it might help to further clarify why it is that we are adding the, the control over daily management decisions, personnel, staffing matters, strategy, so on and so forth, and that right now that stuff is in the public local law under 16-7.
Correct.
Okay, so
Yeah,
please.
so the items that are outlined in those brief kind of sections, daily management decisions, personnel and staffing matters, deployment or investigative strategies, of the 15 items that are included in Subtitle 16, Section 7 of Public Local Law, that's where the powers of the police commissioner are outlined. And so basically kind of condensing what that means into the general category areas. We would also be happy with adding the actual language from the Public Local Law, but just to make it a little bit more concise, had just included those areas.
Thank you. My next question is actually to the law department, just to further clarify. I think I know the answer to this, but I'm going to ask the lawyers. If this were done, would it
Thank you, Council.
would it just supplant one charter amendment with another charter amendment that does the same exact thing? The question is, under Section 3,
Right.
if we introduce the charter amendment that address those concerns, would that charter amendment restrict the city council from passing laws on any of those areas? Or does it merely mean that that is the police commissioner's power to do so?
Okay, let me start first by saying, Acting Solicitor Thompson wishes she could be here and she had a family emergency. So I am filling in, and as far as I understand your question, it would be that the language proposed here would stand in the place, essentially, of what would eventually come in the charter. And once you put what you want in the charter, then the language comes out of Article 2. Is that helping, or is that just restating what you said?
Sort of. I
Okay.
guess I think what we're trying to accomplish here is right now, the police department is not listed in the city charter like every other city agency. It's in public local law. What we need to do is put the Baltimore City Police Department in our charter, just like the health department, just like the fire department, so on and so forth. In each of those departments, we outline the powers of the respective directors. We have not done that for the police department, meaning that theoretically, the council could determine today, we want to take away the police commissioner's decision to hire people. We could do that, well, we couldn't do that today because, well, that's up for debate, given my earlier statement. But the point is, we could change public local law very easily and take away the police commissioner's powers.
Yeah, that's sort of a shorthand way of essentially saying what you have in the charter right now is a sentence that says the police commissioner or the police department is a local entity, but you're right, it's missing what the charter has for all the other entities you listed, like who's in charge, who's the deputy if that person is ill, those kinds of basic structure things that are for other city agencies aren't there. And you're also right that currently the public local law that the General Assembly enacts has a very robust structure of, all sorts of different topics that it covers. So yes, the theory would be that you would put in your charter, you put in the city's charter via charter amendment, whatever structure you wanted it to have. If you leave it with no structure, then of course the questions come up that you say. I mean, who legislates on it and what do you, what could that legislation be or mean? I think everyone agrees that it's better to have it in the charter.
I'll be more specific and I'll give an exact
Sure.
example. Let's say we wanted to, after we've passed this, this charter amendment through a ballot measure, we wanted to introduce a law that changed investigative strategies. Could we do that?
Okay, let me be clear. You mean after this Senate bill passes and then, as written, and then a charter amendment, or no?
If the Senate bill passed with this amendment, and then we did a charter amendment outlining the police department in our charter,
Right.
and it lists in that charter amendment that we're going to read it through, and it defines the police department and the powers of the police commissioner with respect to daily management decisions, so on and so forth. And we wrote a law about daily management decisions, or that had an impact on daily management decisions. Would that law still, essentially, the police commissioner has the power to carry out these things. We have the policy power to make it a law. Is that correct?
I think I'm understanding what you're saying.
Yes.
But if this Senate bill is enacted the way it's written, once you do a charter amendment, then automatically the language in Article 2 changes and then goes and reflects your charter amendment. So if you put something in your charter about the police commissioner and it
Giving him
defines
the
the
powers.
powers and duties in certain ways, then it would operate like every other city entity, and you would be sort of in the same position that you are with the other city entities. Is that answering your question? I mean, it depends on what you write in the charter amendment, right? So, I mean, right. So I can't really say what your law would do with respect to your charter amendment because I haven't seen your law or your charter amendment. But, I mean, assuming it complies, then.
So what I want to ensure is that the language in this amendment doesn't restrict us so much that we don't have the full authority authority
No,
legislative.
the language in this amendment goes away once you do your charter amendment.
Well, no, but it is contingent upon the language that we put into that charter amendment. So the language in that charter amendment must address those things, which is not a problem at all. But once we give those powers to the police commissioner, does the police commissioner having those powers necessarily limit the powers of the city council to write laws on those matters? Is that clear?
Not at all. I wish it were.
Okay.
But my understanding is, I mean, not to be like stupid about it, but you write what you want the charter amendment to say, and you put it on the ballot and people vote on it. So whatever you put in the charter amendment would be like the framework for any other city entity, and so you would be your legislation, just like any other part of the city charter, would be subject to whatever you wrote in the charter. For example, you couldn't pass a law right now that says the head of the planning commission is in charge of picking up the trash. I mean, you already have a structure in place. So, you know, assuming you put in your charter amendment what you want, then you would write laws based on that.
So basically, the state constitution doesn't restrict what we can put into the charter amendment.
Based off of the way Article 2 would be written.
The state constitution?
Based off the way Article 2 would be, so the changes of Article 2, the sunset, that provides no restrictions to the way the charter could be written from the city council's perspective.
I mean, other than all the restrictions that exist now. I mean, I'm assuming you mean just because of this language.
Correct.
Right, like your state constitution would prevent you from being, you know, racist or something, or under those large, like that.
I guess
you
what we're
mean
try- I guess what
because
we-
of this language, not.
I guess what we're trying to get at, Hillary, is we want Baltimore City not to be unique anymore in the fact that there's this paternalistic approach from Annapolis to the city of Baltimore. So I think this approach that the administration is attempting to take is a very unique approach as it relates to sunset legislation. And I think kind of the crux of the questions is if this is enacted the way that it's written, and then a charter amendment is passed from the city of Baltimore through this council, is there any additional tie back to the state that could eventually provide restrictions, meaning with the current language that's enacted, or further potential legislation down the road?
Okay, well, those are two totally separate questions, right?
But I think that's what we keep mixing up. So if you could kind of walk
Okay.
us through both.
So every local government is always subject to the General Assembly coming in and changing their express powers.
That's key.
Okay, so Article 2 is our express powers. It's stuck in our charter, but it's our express powers. For all the other counties, their express powers aren't listed in their charters. So there's confusing, you know, point number one. Ours is in Article 2. And just like with every other county, every other local government, we are always subject to the state government going in and changing your express powers. Once they change once they give you an express power to do something, they can only take that back by changing your express powers.
Gotcha.
Once they give you an express power, then you have it, and you can exercise it normally through your charter, and then once your charter sets up the framework, then you have a local law.
So
So
explicitly.
you always have that, but what's written here would say that once you know, that's all of Section 3, that once, contingent upon the passage of your own charter language defining your police department, you know, long drawn-out sentence, then it goes back to saying simply what's at the, you know, once you pass your charter, then it goes back to reading your express powers go back to reading with no further need to go to the General Assembly. They go back to reading to have and exercise within the limits of the city all the power known as the police power to the same extent the state has, which is what everybody else has. That's the, you know, that's the most unfettered language there could be. So once you pass a charter that sets forth your structure, then you go back to having the most abundant police power that you could have. I can't promise you, though, that that means that someday in the future the General Assembly won't change things again, but based on what this says written here, you won't have to go back to the General Assembly and you get your plenary powers.
Got
Does
it.
that make sense?
It does.
Okay.
And to just clarify one small additional point, and based off of Article 2 and the way Baltimore City is written into Article 2, that is no different than any other jurisdiction in the state of Maryland once this process takes place. Is that accurate to say?
That's my understanding. I haven't double checked with every single county police department, but that's the idea.
Okay. Any questions from the committee?
Yes.
I'll start down here with Councilwoman Ramos and make our way this way.
Thank you, Mr. Chair. Two questions at this moment. One is the first part of the amendment basically says that section of Article 2, Section 27 that we wanted removed stays there until we pass a charter amendment and restricts the types of things that that the council can write laws about, right? Because it basically says that, it keeps the line in there and says, with respect to deployment, investigative strategies, and staffing, right? And that means that if this passes, the time between this passage and the passage of a charter amendment, we could do what?
You can do anything that is not daily management decisions, personnel, staffing, deployment, investigative strategies. So you're getting a change now for broader local powers, but you're basically putting in something that holds the department together until you can put that framework in your charter.
And still allows us to do a few things, right? I mean, we could.
I would think there would
Yeah, I
be
can't
lots
think
of
of an
things.
example.
Yeah, I mean, technology, all sorts of stuff that isn't, I mean, I think honestly that the gist is that you're not putting in a law that says all the officers are fired and they can't collectively bargain anymore and,
Right.
a bunch of stuff like that, because if you do that, then you have a department in
Right.
name only, but no people. So
Right.
it seems like it's just basically a Band-Aid holding it over until you can make sure you put in the charter what you want.
And then following up on that, the second piece doesn't dictate what the charter amendment has to say. It simply says the city council and residents and whoever else wants to be involved would figure out what the structure of the police department is relative to the charter and relative to whatever laws that we want to make.
Yeah, essentially, as long as you put in a charter amendment that deals with those things in some way, then you're good.
Okay, and then my question, I guess, is to the mayor's office or maybe a local control advisory board. How come the local control advisory board didn't make a recommendation on what the charter amendment should look like when we did the charter amendment? Because it seems like we're going backwards and forwards, and we could have had this discussion about what the structure could look like before putting it on the charter, on the ballot in November, because now the residents and our colleagues that are here that have knocked on a bunch of doors are gonna have to do it all over again. So I'm just kind of wondering why that wasn't part of what the work was for the local control advisory board.
It was part of the work. There was not a decision as to the form of local control, and so we couldn't dictate a form without some recommendation from the local control advisory board. What we knew needed to happen is that we needed to take action to create the Baltimore City Police Department, and there was no passion or desire to wait an additional 2 years to get that done. We could have waited and had everything nailed down, locked down, totally spelled out, which is what is going to happen 2 years hence. But we wouldn't be where we are today had we had to wait until such time as the local control advisory board determined the form of management of the police department. We decided that, I guess about maybe 30 days ago, 60 days ago, in January, we had sort of an informal vote on what it should look like. And we are the local control advisory board. We're a 19-person body. If you look at the structure of the local control advisory board, which is what I shared the last time I was here, it is designed to bring lots of views and opinions to the table. It is also a structure that assures that there more than likely will never be unanimity as to what we're doing and where we're going. Although I think we did get, by consensus, an absence of dissent, a decision that the Baltimore City Police Department should look and function like every other Baltimore City agency. And we got to that in January.
So the Local Control Advisory Board was basically doing its work for 2 years.
No, we began our work in November. We began our work, I want to say November 21.
Yeah, from a Senate bill that passed, obviously, during the 2021
Correct.
session.
Right. And so you had been working to get, just to refresh everybody's memory, you were working to get, trying to figure out what the structure would be, but because there was no decision on what that was, decided to go ahead with this initial charter amendment and then come back and say, well, we're going to have to do some more work. Because I guess based on our, if you don't mind, Mr. Chair, I guess based on my, the last hearing that we had, it was my understanding that we could then put the structure in place through a law, that we did not have to go back to the General Assembly to ask for permission to then put a charter amendment to then go in. It seemed like we had an opportunity, and it was clarified with the Law Department's memo that we got later, which basically said, and I hope the committee was able to get it, I didn't send it to the whole committee, but that once Article 2, Section 27, that line comes out, that the city council could actually change the public local law. And that's what we want. And so I guess the hesitation on going forward with this additional step is we're going to pass this, we're going to have a little bit of restriction, then we have to go through the whole process of not just the Local Control Advisory Board, but also the council and this committee saying what kind of structure it should be and what kind of laws we want to make, when we could have done that anyway when we've got the Article 2, Section 27 removed. So I'm just kind of confused as to, I get why we're trying to put some fence posts around, I understand that, but it just seems like we would have had to do that anyway.
I can't really answer the policy issue, but I can say that it's not really that I'm probably the only one in here that cares, but it's not really that your local city council law would repeal the public local law. It's, it would just be that on similar topics, if there's a conflict, then it's likely your law would be seen as the one that prevails. And I think, I'm assuming you also got the AG's opinion on the same topic.
We have not received the AG's opinion.
We do have the AG's, I just got it today. And the AG's opinion is equally opaque.
Great, wonderful.
It says in some ways that the concept of the city council not having legislative authority is absurd, and therefore we do have legislative authority, but then also says that if that were the case, you can legally challenge any of the laws that we pass in that time, so we might as well strike Article 2. Strike Section 27, Article 2.
Can you send that to everybody?
Yes,
I didn't
will
get
send
it.
that. Yes.
I mean, all I can simply say is both the AG and the Law Department's opinion reached the same conclusion that Article 2 should be changed. And I will say, I know of no other local government exercised power that the government had before the state was formed. It got taken away, and now it's supposed to come back. So it's not because we're sitting around not doing anything. I think this is probably the most challenging question I've seen in nearly 15 years, because there's just not, we don't make up the rules. You're judging what you think a judge might think. And as you see from the AG's opinion, they're going, well, I think this must be how you might read it, but there's no precedent for this. You can't look to another county and go, oh yeah, that one existed, prior to the Revolutionary War too. And here's what happened when they took a power away from them in the mid-1800s and then waited 160, 70 years and gave it back. It's just both sets of lawyers agree that the safest way to do it is to fix Article 2. But other than that, what could you have also done? There's not a lot of consensus, and that's not surprising because there's just not any precedent for this.
Yeah, because the way that I read the law department's opinion was the public local law, which still exists, right? Because the 2021 law struck two parts of the public local law. So the public local law that still exists is 16.7, which outlines the power of the commissioner. And it basically said, you know, if we change Article 2, Section 27, that last line, that we actually could change the public local law.
And that is one way to read it. And the AG comes out and reads it slightly differently. And there's no real right answer to this because it's never been done anywhere in Maryland. So it just depends on if you go ahead and enact something, is a court going to uphold it? And,
Right.
you know, I mean, when the powers of the police commissioner were changed in the 1860s after the Pratt Street riot, there was plenty of litigation there. And so you think, oh, well, you just undo it. But it's not, it's apples and oranges. It's
yeah,
a completely
right.
different world. And since that time, you know, back in the 1860s, there was no other local government but Baltimore City. And then you've got the layers of the Maryland Constitution over that saying, oh, well, you can have local control if you go through this. Well, we already had local control. So how do you read those layers? I mean, it's not an easy feat, but in short, both the AG and the law department conclude your best bet is fix Article 2 to avoid a challenge. If you don't, it's kind of anybody's guess how it would read and what it would do.
Yeah, I have a couple more questions, Mr. Chair, but I'll circulate it around. to
We can
others.
come back around on the second round. Councilman.
Thank you, Mr. Chair. Thank you to the folks who are here with us. First, just seeking to understand exactly what would be permissible from a legislative perspective. So, for example, in 2020, we passed legislation to enact trauma-informed care and have all city agencies sign up and get trained. One of the agencies we did not include in that bill was the police department because we couldn't. That is obviously an agency that very, very badly needs trauma-informed care. If this particular, if this amendment were to pass, at that point, could we name the police department as one such agency? And my follow-up question to that, just kind of relevant, I know my colleague has some legislation around banning or changing facial recognition technology. Would that be permissible? Just really want to understand the parameters for what this would actually do.
Great questions. I'm assuming when you say amendment, you mean the Senate bill.
Yes.
Once the Senate bill passes, are you asking what can be enacted between the passage of the Senate
Both.
bill until your charter amendment?
I'm interested in that period, and then I assume after the charter amendment, theoretically, anything we put into it, but tell me if I'm wrong here, but particularly in that period where we don't have a charter amendment, what happens there?
If the Senate bill were to pass as amended or as written right now,
Yeah.
the express powers, the General Assembly would be giving to the city greater express power over the police department, except over daily management decisions, personnel, staffing, deployment, investigative. So your question about things like surveillance technology, about things like trauma-informed care, the devil's in the details. You know, to the extent that those, and again, I haven't memorized the text of either of them, but to the extent that those would conflict with daily management decisions, personnel, staffing, and deployment, blah, 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 then no. To the extent that they wouldn't, then yes. And then once you put in the charter amendment, you would structure it however you wanted. Does that make sense?
It does. It just leaves a lot of gray and
The whole thing
vagary.
is gray. I mean, there's been absolutely no other local government that's ever had to go through this in Maryland. I don't know if anyone in the country. I mean, this is sort of the most unique thing I think I've ever seen. And you're not going to get, I would imagine you're not going to get many lawyers to agree on it because, I mean, we don't make things up. We're just reading cases, precedents of stuff that's similar that's happened, and there is none.
That's concerning. I guess my other question, and this is maybe not so much for the law department, this probably is for the administration, is I'm still not clear on why this amendment is needed. It seems like a lot of folks in this chamber, frankly, have done a lot of work to underpin the legislation to get us to a place where we all have kind of a common understanding that we would be able to have local legislative control over our police department. As my colleague was kind of saying, this seems to be a step back or a step lateral. So I'm just kind of still trying to understand the rationale for why this is needed.
Yeah, so I think that like one of the things to point out is that in other jurisdictions, typically their police departments are codified in their charter, and there are a number of powers that are not something that the local councils or legislative bodies can legislate. And so what I've heard time and time again from elected officials and from members of the community is we don't want to be unique anymore. We want to have local control. We want to make sure that our powers are right-sized and that we have control over our police department as we should. And so this language, all that does is align us with those other counties and those other jurisdictions that have local control of their police departments until the point where we actually are able to, as a city, as a community, vote on the actual structure of that police department and of the powers of the police commissioner and on any other duties that we want to make sure are in that charter. So the amendment language is merely to make sure that there's alignment between other jurisdictions and us until we actually are able to make it a more permanent solution in codifying it in our charter.
Understood, and I appreciate that response. It just feels somewhat duplicative. I feel like when folks voted the first time on this, they were pretty clear about what they were voting for. They wanted the local legislative body to have local legislative authority over their police department. And so, again, to me, this feels like a step forward to move back and just doesn't feel in alignment with us being able to quickly move all this forward.
It does kind of feel like a do-si-do, doesn't it?
It does.
Yeah. But if you look at the city charter for every city agency, except mine, there's a real delineation of what the duties and responsibilities and the management actions are. It's really well spelled out, and in some instances, it can go on for a page or 2 pages or even 3. And that needs to happen. That always needed to happen. Some of you all might recall that when we were talking about Question H, one of the things that was said is it's the shortest ballot question ever, and it was. And that was very intentional that it be short, because that was sort of an acknowledgement that the Local Control Advisory Board was not necessarily in alignment with itself. There were so many different views, and we spent a lot of time bringing in subject matter experts from across the country that were talking with us about the different forms of local control. And we really hadn't decided. We were not at a point where we were ready to decide, but what was very clear by everyone to a person was that we needed to move forward in 2021 and get something on the ballot in 2022. So, you know, I've shared with other people that when I first started drafting the ballot question, I started putting in all of those things that, you know, that are listed for every city agency. And then I realized I can't do that because the Local Control Advisory Board hasn't made those determinations. But what it had determined is that now was the time, or that then was the time, and that nobody wanted to wait until 2024. So we realized that we could get a ballot amendment that accomplished the requirements of the enabling legislation that established the Local Control Advisory Board. We could meet those requirements by having just a short amendment that said there is a Baltimore City Police Department. So we got that done, and everybody, you know, I think you will hear there were a lot of people in this room that did door-to-door, knocks, et cetera, and got that Question H passed. But we need to come back and say there is a Baltimore City Police Department, the purpose of which is, and then go on for those 2 to 3 pages and get that done. And that only happens by a charter amendment. In the meantime, you know, there are the public local laws, which are pretty extensive, and those are codified in Article 4 of the Maryland Code of Public Laws for the city of Baltimore, and they go on quite a bit. So in the meantime, that's what we're living with. what we want to make sure, we haven't talked about it tonight, and I don't think we need to talk about it at length, but we are still under the jurisdiction of the federal court. The Baltimore City's consent decree for the police department is still in effect. The chief judge oversees it. He's very active and involved and aware. And you know, one of the things that we did do when we were looking at you know, what we were going to do as an LCAP, we brought in the consent decree monitor, Mr. Kenneth Thompson, and asked, what's the impact? And it was determined that local control would not have a negative impact on the consent decree. But what we didn't ask is how the consent decree impacts local control. And so I've had that conversation. I've gone back to him and said, look, you know, we got, you know, we're trying to change 163 years, and I want to do it in one step. And his response is, I can't tell you how to do it, but what I can tell you is that whatever is done must not conflict with the consent decree. It must not interfere with the consent decree. In terms of any legislation that gets passed, it has to be consistent with the consent decree. And I'm like, well, what does that mean? He goes, well, I mean, I won't tell you what he said it means, but I can tell you what it means. If we do something that violates the consent decree, then we are subject to being held in contempt of federal court.
Director Moore, I want to.
Oh, you want to stop me?
The president
Okay.
has something he wants to
Oh,
add.
I'm sorry.
Yeah.
Sorry, I'll stop.
I'm just going to say to kind of go back to Councilwoman Ramos and Councilman Cohen's point. I mean, the reality is the work or what was done in Annapolis originally, I think the frustration is could have been less restrictive for us to have this discussion a lot sooner. I know on the LCAP, you know, I was very vocal when we first started the call of my level of disappointment associated with what was passed out of Annapolis, because it was going to eventually be us kicking the can down the road. I know, you know, folks, I see Ray Kelly, who's part of the LCAP, that was right there seconding it, but unfortunately, the way that the bill was written in Annapolis and was ultimately passed out in Annapolis, the bill that was chosen in Annapolis was very restrictive, and it tied the hands for us to be in the position that we are in today. I think that is where a lot of the angst is, particularly of myself, as it relates to this bill and really trying to work with the administration, enforcing some level of unification out of City Hall to go down to Annapolis in support of one bill that is the least restrictive, that really undoes the paternalistic ties associated with the state and local control here in Baltimore City. And I think that's where we're hearing the frustration out of both council members. But it really started with that first bill out of Annapolis that this body had absolutely nothing to do with, but that was ultimately kind of the motivation or the approach that Annapolis took. The only thing I'll also add to your point, and I'm gonna be very clear, and I think that, you know, we've been talking and working with the mayor and the police commissioner and trying to really drive down this way of like what the police commissioner powers are. And then we talk about the consent decree, and yes, the monitor came out and he did a really good job of laying out where we were with local control and the consent decree. Is that, you know, we have an amazing law department, right? So, you know, the fact of the matter is, I just don't want to paint this picture that the sky is falling, and I know that's not what you're doing. I just think it's good to put on the record that obviously no one on this committee, no one on the council is going to want to get in the way of the consent decree. Actually, we want the consent decree to work, and we hope that, you know, we get to a point where it's working so well we can dual it down as it relates to the expenses associated with the consent decree. But the reality is we don't want to negatively affect it and impact it, and we won't. And I know the law department will be standing firm on ensuring that that doesn't take place. I know that the mayor works directly with the monitoring team as well with the judge in this to ensure that things like that won't take place. So I want to make sure that we put out in the atmosphere that, you know, nothing that will come out of this council will be at the demise of what the consent decree has put in place and is intended to put in place. And I think that's really important point to mention.
I really very much appreciate it. And you know, I've worn a lot of different hats since I started working with the city, and I have enjoyed each and every one of them. And one of the things that's been really difficult is that this is you know, the Local Control Advisory Board, you know, we are different. There is no one single view, other than we want what's best for Baltimore. And you know, for all of the work that we've all been doing over the last, I'd say month, or really since the legislative session started, to a person, everyone has acted in the best interest of the city and moving the city forward and making sure that we are in a position to have a police department that acts the way we want it to act, that does what we need it to do, that delivers public safety the way we know that we need it delivered, and that is unfettered in its ability to do so. And I believe that everybody who I have engaged with and who we have all engaged with over these last weeks has that best spirit in mind. We disagree on how we get there, but we all know what we want and where we need to be. And you know, I keep doing the math. We lost local control in 1860, and that is 163 years. And we are really trying to, and we lost it for good reason. We did. We lost it for good reason.
Can you give us a history lesson real quick?
You would, yes. It's on tab 1 of the.
I mean, we're talking about it. The
Okay.
folks should know about it.
So Baltimore City was founded on July 30, 1729. The Baltimore City Police Department was founded in 1784. On March 16, 1853, the Baltimore Police Department was officially established by the Maryland legislature. In 1859, the Maryland General Assembly passed a bill transferring control of Baltimore Police Department to the state of Maryland. So for just 6 years, we had control of our own police department. January 1860, the Police Act of 1860 created a panel of 4 police commissioners that were appointed by the General Assembly. There was a time we had 4 police commissioners. And then a whole bunch of stuff happened between 1860, and it really wasn't until 2009 that the Maryland General Assembly turned the police commissioner back under the control and authority of the city of Baltimore, but we still didn't have control of the police department. The commissioner was allowed to be appointed by the mayor and then approved by this body, by the city council. And I have a footnote that, you know, Brandon Scott joined the city council in 2011 and really made local control his priority. One of the hallmarks of that, 2014, the Baltimore City Council attempted to pass an ordinance regarding body-worn cameras. That was blocked because at that point, the Baltimore City Police Department was a state agency. It was not a city agency, and you couldn't legislate over a state agency. And it's in January 2017 that the city of Baltimore entered into the consent decree, which we are still living with. March 2017, House Bill 1504 was proposed. It passed in the House, I believe, but it was ultimately withdrawn. That would have given local control. Other attempts were made. You talked about Ray Kelly. In August 2018, the city's Community Oversight Task Force recommended restoring local control of the Baltimore Police Department. That was a great idea. Here we are. We're getting there. 2019, the House of Delegates passed a bill unanimously restoring control of the police department. That bill stalled in the Senate because there were Attorney General opinions that talked about liability, and that there would be increased liability, and it would be very, very expensive. Well, you know what? It's really expensive. We spend a lot of money settling cases. So ultimately, a decision was made that just was not a huge factor. So April 2, 2021, House of Delegates passed House Bill 1027, giving City Council authority to pass ordinances regarding police department and establishing the Local Control Advisory Board. Things moved pretty fast after that.
Which was the compromise that puts us to this point right now.
Right, and we had our first,
2019.
yes, and I can tell you that it was on October 27, 2021, Mr. President, that you raised the concerns about which you are raising today. And we have,
I don't say I told you so. I don't say that.
no, but I hear.
Well, I told you so.
You and I had the conversation.
Yeah.
Well, yeah, I carried it from the General Assembly. I started in 2020. I was there for the 2019 vote, but we're not here to talk about it.
Right, but I just
want you to go over the history, and I really appreciate that.
Okay.
That way everybody can understand how do we get to this point and really the frustration of like where we move forward. So there's not a hitting can that's also kicked down the road for us to be back here. And I think it's just fair to put on the record. That's the point of, thank you for the leadership of Chairman Conway for really pushing at this issue, really digging down into it. But that's the reason that we're really all here tonight, because we want, from a City Hall perspective, for all of us to be on the same page to ensure that Annapolis is doing exactly what the citizens have overwhelmingly gone out and supported.
Absolutely, and I do thank Councilman Mark Conway for his leadership. I've been practicing law for a while, and it's the hard questions that are the most uncomfortable questions, but it's the hard, uncomfortable questions that cause us to be introspective and to really think, and that is the process that we need to do in order to come to a place where we all can live with the decision. And I know that there was a lot of work. It's been ongoing. We're at a point where the amendment that Ms. Themelis described really is the one that we need, because one, you and I talked about that. It goes to the trust gap. It goes to the need for this body to do its work and to be protective of all the things that we've already talked about, for the police commissioner to lead and do. I don't know that the Local Control Advisory Board is going to be the one to draft the next charter amendment. I don't know if we can be held together, but we know that's what needs to happen. And you've created an amendment that I think gets us where we need to be and lets us move forward. Maybe not everybody will be happy, but I do know that the city will have what it needs to manage and support its police department.
Thank you. Councilman Burnett.
Thank you, Madam Chair, Mr. Chair, Mr. President, and everyone who's joining us this evening. So I just had a question. You mentioned that there, I guess, would be a need for additional processes, community processes, legislative processes to draft the charter amendment. What I'm trying to grapple with is, I think that's great. How is that different than what the Local Control Advisory Board is supposed to be doing? And sort of feels like the LCAB is going to come up with some sort of recommendation, and then there's this separate and hopefully equal process outside of the LCAB, but then it becomes whose decision to square the two if those processes are different. But I also just don't understand what the need is to have a second process.
Yeah, so thank you for that question, Councilman. So the work of the Local Control Advisory Board was to put forth a recommendation for a model for the police department, but it is the legislative body's responsibility to actually determine whether or not that structure is what the will of the people is. So it would be, through the actions of the City Council that charter amendment, the structure of the police department, the parameters of what the powers of the police commissioner would be, any other items that you would deem necessary to be included in that charter amendment, so that the police department is reflected in the charter as many other, if not all, other city agencies are. So the work of the board is to do that kind of background research and to provide examples and recommendations as to what they see the best fit for Baltimore being, but ultimately it's the legislative body's ability as far as actually enacting a resolution to then put that ballot measure onto the next election cycle.
And under this scenario, what would be the timeline? When could the council and the public expect a deliverable that would give us enough ample time to vet publicly, to have this sort of more robust legislative process, hearing process? When could we expect something?
So the Local Control Advisory Board has committed to have its final recommendation, I think I said April 7, 2023. And as candidly, our work has increased a little bit because of all the things that we've been discussing over the last month and a half. But that's okay.
Yeah, I was going to say, I do want to add on to that there's nothing that would prohibit the council from starting that engagement and starting that process in advance of a recommendation. So as far as like the basics from other jurisdictions or the basics from the charter that exists for other agencies, that process, there's no need to wait for that recommendation to come forward to begin that process.
And I'll add, it's our responsibility to pass the charter amendment. Now, it would not go into effect until after the ballot measure. So we'd be in a situation where the November election would be where they'd have the ballot measure for this bill.
Yeah.
Got it.
And Councilman, I will provide you with, I don't think I gave you one of the notebooks.
I have one.
You did? Oh, okay. Yeah, so tab 4. Shame on you. Okay. Tab 4 has our reports that we've submitted so far. So you can get a sense of where we're going to go with what I think will be the final report.
Got it. Sorry, I have one
Go
more.
for it. Yep.
On and perhaps you may not have this answer, but for the law department, how are things like deployment strategies and investigative strategies defined to your understanding? Is there, I think it would just be helpful to kind of understand that if this were to pass, what does that actually look like? And it sounds like maybe we don't have the answer to that because it's unprecedented, or are there other jurisdictions that there is that could point to say, well, they're doing X thing in Montgomery County or Baltimore County, or even this example of body cameras, like is that a investigative strategy? Is that, or what Montgomery County is looking at a proposal by Councilmember Jawando on eliminating minor traffic stops. Is that a deployment strategy that's being amended? Like, how do we know where those fault lines are? And what basis would you as the law department in coming up with a report out on where, if that line has been crossed or not, what would you be basing that on?
Right, it's a great question. So when we look at legislative language in general in anything, a charter, an ordinance, here would be a General Assembly change to Article 2. The first thing is the language plain and unambiguous? And if it is, then that governs. So that's sort of the first line. And then beyond that, if it's susceptible to multiple meanings, there's a whole litany of guidance that is given. It's called statutory construction, and that's what we look through, and there's certain principles of those that govern. I mean, one easy one is latter enacted usually governs over earlier enacted. I mean, it's sort of these little tenets, mantras, whatever. To your specific question, it depends. I mean, sometimes it's going to be obvious if your bill, I don't know, is on, there must be 5 officers on Thursday. That might look and quack very much like a deployment or HR thing. So some of them, it's not going to be rocket science. It depends on what it is. When you get down to the nuance, that might be more difficult, and we would do exactly what we always do in the law department. We will say in the bill report, this is your potential risk. This could be challenged. If you'd like to tighten it, this is what I would recommend. And that's the same advice we give you. I mean, looking to other jurisdictions here does not do us a ton of good, because not only did you hear the 160-plus year history, but the reality is the only very tiny time that we had local control, we weren't really in control. We had a bunch of commissioners, a sort of group of commissioners, and even then, that was before the current Maryland Constitution, which gives express powers, and that whole phrase, express powers, didn't exist when we had the police department the last time. So yeah, I mean, we don't know, but it doesn't mean that we're lost. It just simply means, like with anything else, you'd go through those steps of statutory construction. So whatever bill you put forward, we'd look at it and give you basically, as we always would, a risk analysis. I mean, most of the time, most of what the city council passes is legal. I mean, you have the largest bounds. Your constructs are only state and federal. That's not true. Once you write a law or something, I mean, it's much more restrictive. Once you're on the executive branch side, you're constrained by the local law, the federal, the state also. So, I mean, just like with any other bill, we'd give you, we would give you the sort of best analysis we could, and then it's sort of a risk analysis. But because this is going to be so limited in time, and you would need a charter amendment which would be effective by what, like December 15th-ish, 2024, it's not going to be that much time, so your risk is going to be low. I mean, you pass something and it looks like it might impinge on this. I mean, the window of impingement is low. I mean, it's not a permanent situation, so that'll factor in as well. Something you pass today, could be seen much more favorably past December 15th of 24, if that makes sense.
Okay. Yeah. Thank you, Mr. Chair.
Thank you. Quick question before I go to Councilman Porter. Do we have an Annapolis sponsor?
Could you clarify the question?
Do we have a sponsor for this amendment in Annapolis?
In which side?
Either.
On
Both.
either side, so it hasn't been introduced yet, so there is not a formal sponsor.
There is not a formal sponsor yet.
Formal sponsor, no. It hasn't been introduced yet.
Okay. Councilwoman Porter.
Thank you, Mr. Chair. I did have a question related to the language in Article 2 of the general powers. One of the things that I'm conflicted with, the police department historically in Baltimore has had significant cultural issues with regard to hiring and officers that have done bad things in the past that are still on staff at the police department. And they're still like on staff at the police department at this current moment. I'm wondering, is there an opportunity to add some language that kind of allows the city council to remove those officers from the staffing model? Like, one of the things that I think I'm getting hung up on again is just providing, like, I know each agency head has the powers to staff their own operations. My issue, and I think the collective issue with some of the constituency that have shared with me, is that when the police commissioner and or the powers that be do not enact in the best interest of the community, therefore, we as city council representatives, we are kind of, being representative of what the community wants in order to move said officers from the department.
Thank you for the question, Councilmember Porter. So as far as like the personnel element in the bill, obviously that would make that action not possible, but I do want to just draw attention of the council to a separate bill that we have that is introduced and moving in Annapolis that is in reference to the Civilian Review Board and transferring the investigatory powers of that board to the Police Accountability Board. And so that's important because right now the Civilian Review Board is restricted in only being able to investigate 5 areas, whereas the Police Accountability Board does not have those restrictions. And so being able to have that body perform investigations and then make recommendations to the Administrative Charging Committee that can make those charges against those officers, I think will produce the same result that you're seeking.
Thank you for that, Ms. Themelis. And so what's the outcome of the Charging Review Board? So if it's determined that the officer has done not good things and is still going to be employed at the department, what are the aftermath actions after that?
So I was going to say the Administrative Charging Committee, and I'll allow Chief Moore to speak more specifically to that, but the difference between how the Civilian Review Board acted previously and the way that the Police Accountability Board / Administrative Charging Committee act, previously and up until now and through now, the Civilian Review Board makes a recommendation and provides that to the Police Commissioner for action to be taken in a certain incident that has been investigated. The Police Accountability Board has a separate process, and I believe Chief Moore seems like she wants to talk, so I'll turn it over.
Well, yeah, we're straying into to a little different territory, but it's really, really important. Also because of actions that took place in the Maryland legislature in 2021, we have the Police Accountability Board. This body helped us fill that board. It is fully functional. They've had a couple meetings. They have selected a chair. They are beginning to staff up the Administrative Charging Committee. All of this is working in large part because we were able to address the ties that were put on all of us by the Law Enforcement Officers Bill of Rights. That is not in effect. And so police commissioners and councils and all of us can move a lot faster in removing bad police officers. The Police Accountability Board is going to have far broader powers than the Civilian Review Board. They'll be able to investigate, all kinds of concerns that come to us of complaints that come from citizens regarding their engagement with officers that are not acting appropriately. So, yeah, I mean, I don't think that this body wants to be able to, reach in and be the ones to actually remove any employee of the city. You don't want that. Yeah. But you do want someone to be able to do that, and that's the PAB.
Yeah, and so the reason why I asked that, because, the language as it's stated is the police commissioner has a power over any daily management decisions, including personnel and staffing matters, deployment, and investigative strategies. What if that fails?
So I'm not, well, the Police Accountability Board stands, and the Administrative Charging Committee stands, and those aren't going away. And you know, the police commissioner does have a role in police officer discipline, but ultimately, you know, the state decided there should be something different. So every jurisdiction has a police accountability board, everyone. You know, ours is the largest because you guys decided that you each wanted to be able to appoint someone to the police accountability board. So that's happened. And, you know, the police commissioner, as it's written, does have management of the day-to-day, but that there is no carve-out for discipline. And it doesn't say you have, you know, management of the day-to-day and you have total control over disciplinary matters.
Okay.
My office is supporting the Police Accountability Board and the Administrative Charging Committee, and we will not be letting that go.
Okay.
Okay, thanks.
Thank you, Councilmember. President Mosby?
Just one small quick question. I think one of the things that are kind of floating around, I'm not sure we got an explicit answer to yet, is there a legal definition to investigative strategies?
Not that I know of. I mean, for one, that's not, I mean, I assume that's proposed language. I don't know. The General Assembly could pick a different word. But then ultimately, again, it's kind of what I said to Councilman Burnett. You know, we're just going to, you kind of know it when you see it, if it's in or out of those bounds, but if it's in a gray area, we're going to do our best to give you sort of like, this is the risk you run, this is coming up to that line. I mean, that's really the best that we can do, because there is no similar language exactly like this for, you know, the same situation anywhere else in the state, so.
I think that's where we keep getting back to, I guess we don't want Baltimore City to be kind of the sore thumb, particularly for this issue in the state. And we really want to try to get away from, again, the paternalistic nature, whether it's tied to Annapolis or it's tied through laws that we codify for Baltimore City, as if this legislative process that this council is in charge of, or ultimately what the voters of Baltimore City ultimately decide, who, you know, quite frankly, per capita might be some of the folks in the entire country that have been subjected to issues that we are kind of pushing away from, and we have a federal consent decree in place. Well, but I think that those are the types of issues or concerns that, quite frankly, this body continues to have with going down this approach.
Yeah, no, that makes a lot of sense. I mean, unfortunately, we're not starting with a blank slate. We have all of what's in the public local law and all the past history. So given what you have, this seems to be politically and legally where you are. So again, all we can do really as your lawyers is just try to give you the best view of what the final words mean once they're enacted, based on, again, you know, sort of statutory construction. But absolutely, there's no one thing I can point to define each and every one of these words.
Yeah, understood. Or we
Yeah.
could take ambiguous terms like investigative strategies out and maybe specifically say what we're trying to do, or just work through the legislative process to ensure that we don't get to what, you know, we think could potentially be in harm's way. And I think that that's been kind of the pull and the push. And I don't know if we're still not there when we talk about a term of what investigative strategy means.
No, that makes sense.
Member Ramos.
Thank you, Mr. Chair. So I just quickly read through the AG's opinion, and not a lawyer, so just what I'm understanding is basically we could start making laws. And it's just that taking out Section 2, Article 2, Section 27, the last line, would clarify that we have the authority to do that. That's how I'm interpreting it.
I mean, that is an excellent read of what was said. I can tell you there's a lot of disagreement about whether or not that would really be how a court viewed it. It would be unprecedented to have the General Assembly alter the express powers of a local government with a public general law. I don't know of any other instance in which that's happened. And so it's unprecedented. However, that's the problem. The whole thing's unprecedented. So we really don't know what would happen if you were to, put in a bill tomorrow and outline the entire police department and the language of Article 2, Section 27 still there. We would probably give you the same bill report as we would for most of this. This is the risk you run. Here's the challenge that could happen. And so, I think they're acknowledging the same possible challenge. If Article 2 isn't changed at all and you would just go forward, it's an absolute question mark what a court would do with that. I imagine it would go all the way up to Maryland's highest court because it would be probably the question of the decade legally. Yeah.
Right, well, yeah, right.
Let's not do that.
So they're saying basically you gotta take out Article 2, Section 27, that one particular line. And so I guess the question is, that we'd have to put in a charter amendment to define the powers of the police department. We have, just to make it consistent with all the other agencies, so that, I guess, makes sense. So I guess my question is to the Local Control Advisory Board, to the mayor's office, what are you afraid of with the council having the power that the voters thought we would have?
You have the power that the voters thought you had. That's what the Attorney General opinion says. You have the power, and you've had it since January 1, 2023. You've had it.
Right, but what I just heard from Hillary was, well, that could be challenged because of the line, Article 2, Section 27. So my question is more about why are we even going in this direction with the amendment if we know that at some point in time, we know we have to do a charter amendment. I think we've accepted that, correct, Mr. Chair? Okay, so we know that we have to do that. So the issue is just, why is it that we then are restricted in a way that, I think what I'm thinking about is, like you mentioned, the consent decree, right? The consent decree, I get it. If one of us puts in a law that screws up the consent decree, the law department would tell us, the judge would be all over us, and we'd work together to try to make sure that doesn't happen. If I put in a bill saying I want all the police department in my district, my colleagues would be like, that's not going to happen, right? If we put it, I'm just trying to figure out, I get it, we need to put in the structure and the charter amendment, which I wish we had done before, but I'm just trying to figure out what exactly is the rub here for allowing us to go ahead and start doing this. And so I guess I'm just trying to figure out what folks are afraid of is all I'm trying to figure out.
Yeah, and so I thank you for the question, Councilwoman. I don't think that there's a conversation or thought around fear of action by the council, especially on intended consequences. I think it's just mostly about clarity and certainty and making sure that there is a very specific process, because as we've heard from the law department, the history of the city law department is unprecedented, or police department is unprecedented, and we haven't had a clear roadmap to get to where we are today and to get to that finish line. So the language that we're proposing is so that everything is clear and everything is certain. It's not about any issues of trust with the body of the legislative branch. It has nothing to do with that whatsoever. It's just making sure that as we carry this police department fully under local control, and to your point, there already is a fair amount of legislative ability that the council has. So it has nothing to do with fear or with not being able to trust the members of the council. It's just making sure that from this point forward, we're clear, we're transparent, and we're able to say, okay, this happens this year and no further action is required after 2024, period, by the General Assembly. It has nothing to do with a lack of trust within the body of the council.
Except that you're putting in legislation or language in the first part of the amendment that says, we can't make laws based on deployment, investigative strategies, staffing, and whatever else the fourth one is. And so, and because it's a little ambiguous, as was pointed out earlier, we could propose something and the law department will say, meh.
I think it's actually more, and correct me if I'm wrong, because again, I'm filling in, but it's more to preserve all those topics that are currently in the public local law. I mean, the public local law in the police department is, if you took that wholesale and put it in your charter, it would double the size of your charter. I mean, there's tons of rules, and the majority are on those topics, and so the thought is to preserve what's currently there until you get a chance to change it, and not be in a situation in which you have nothing in the
We just
in that. And it would be for things like collective bargaining and that kind of stuff. It's not, it's to sort of keep that structure that's already there, because one of the things the AG's opinion doesn't address, one of the complications is you aren't in a vacuum. You're not starting from scratch. You have pages and pages of public local law. What do you want to do about what's there? And so this would actually clarify that you, as Commissioner Moore said, you have a ton of legislative power right now, but you're holding in place what's in the public local law until you decide how you want to change it in the charter, if that makes sense.
Because the law department said, once we remove Article 2, Section 27, that little line, that we could change Public Local Law 16.7.
Well, that is the crux of part of the legal analysis here, because that public local law a lot of it pre-existed home rule power in the state. This is not a cut and dry problem. So if you had no public local law, then this would look like restrictive language. But it looks restrictive on its face, but it's actually the opposite, because you're in a world of having a ton of existing laws. And so you might have the power, as we mentioned in our memo, to change going forward. You don't want to be in the situation in which you have nothing in the present. It's like affirming what's currently there. It's less about restricting you, if that's making any sense. But that's sort of, you're not in a vacuum.
So you believe that, so let's say we change that to say, to cite Articles, Public Local Law 16.7, which restricts us even further. You're saying the language that we put into the amendment actually doesn't restrict us as much as the public local law does.
Absolutely.
Okay, I understand now.
Yeah, I mean, but being silent on the existence of the public local law, again, you don't really see this. You don't get public local law on a topic. You can't get public local law or public general law on a topic for which the General Assembly has given away express power. So this doesn't happen anywhere else. This is the only instance in which you had 160 years worth of laws. What happens to them when you're basically transferring legislative power from the General Assembly to this body? It's not a situation that has ever come up before, so you're going to see a lot of that.
So don't we have to repeal 16.7 in order to give us the more broad approach that's in the amendment? Or
For Article 27?
No.
I mean, for Section 27?
Yeah.
No, because Section 27 is your express powers, and right now it says you can't legislate. And so you're changing that to say we can legislate, except we're holding on to the public local law on these areas like collective bargaining until we make a further change.
So, Councilwoman, I did promise folks the opportunity to testify.
I'm sorry, I got into a
No, this is a fascinating scenario. I just want to make sure I give folks an opportunity to speak up. I know this is a lot of information, and I thank you guys for sitting tight, listening up. We're going to give everyone 2 minutes of testimony, and for folks who are joining us virtually, please use the raise hand function, and we'll acknowledge you. We'll unmute you. We'll start with the folks in the room. You've got 2 minutes, and first up, we've got Liz Simon Higgs.
Good evening. My name is Liz Simon Higgs, and thank you for welcoming me here tonight, council members. We're here for a couple reasons. One is that our police department has been a state agency for a very long time. And another is that these are the people who fund that agency. And I did the math very, very quickly. And if you take and this was actually a couple of years ago now, so if you take like the budget appropriation to the police department, and this is before overtime and all of that, we taxpayers pay about $1.5 million a day to the police department. And right now, our city elected officials have This council has no legislative authority or control over that. It's been a long time. And I feel a little frustrated because I looked closely at this bill a couple years ago, and we really could have done this in one fell swoop. We didn't have to have the charter amendment or we didn't have to have the ballot measure this past fall. We wouldn't have to be back here if we had struck this language in the charter a couple years ago. And my understanding was that the Local Control Advisory Board's job was to wrestle with what happens to the public local law, because that was kind of a new area. I'm a member of SURGE, Showing Up for Racial Justice, and we are asking that the council supports no amendments to the current bill before the MGA. It's just going to delay things further, like a lot further. I mean, the earliest anything would happen is 2025. I think you've heard the law department talk about all the gray areas, and I'm not clear what this council would actually have the power to enact if the proposed amended language in the bill were passed by the MGA. We elected you. We trust you not to micromanage, and in fact, you can't, because we have these public local laws on the books. You asked really good questions about facial recognition technology and trauma-informed care, and I think these are some of the most important, basic, huge questions facing our police department, and I appreciate your leadership. Thank you.
Thank you. Next up, we've got Jonathan Rokan.
Hi, thanks. My name's Jonathan Rockhind. I've lived in Waverly about 16 years. So I understand you're discussing taking areas, my understanding is you're discussing taking areas of BPD that previously had Democratic oversight from Annapolis and legislatively make them out of bounds for any Democratic oversight at all. For some years, I've been involved in lobbying for BPD local control and accountability. And over the years, we've been told that we've achieved political victory after victory. But it always seems like there's just one more needed before we see changes that actually happen to address the crisis in police accountability and transparency. So to have the outcome of all of these so-called victories be less accountability for BPD than we started with when Annapolis used to have oversight of these areas, literally the opposite of what we've been working for, it seems profoundly anti-democratic. And as far as I know, no other Maryland cities have a charter set by Annapolis that limits legislative authority over the police. That would be special to Baltimore. I don't think Baltimore needs to be different than every other county and municipality in Maryland. So if another charter amendment is needed, that's fine, you can work on that. We know it's gonna be 2 to 3 years minimum until that happens. In the meantime, what we just heard is every time the council wants to legislate on something, the law department's advice is gonna be, it's a gray area, we're not sure. You should really wait until the next charter amendment in 2 to 3 to 4 years. We're kind of done waiting for that. We've had, so many times it's been like, oh, you won this, it's ready. Oh wait, we have to do one more thing. We don't want to wait another 2 to 3 years. So that's fine if there needs to be another charter amendment, but in the meantime, change the article to say that what you should support, you're the city council, support giving yourselves the same legislative powers, same general powers that every other county in Maryland has. There's no reason to restrict it for those 2 to 3 years until the subsequent charter amendment gets passed. Thank you.
Thank you. Next up, we've got Molly Amster.
Sorry. Thank you, Mr. Chair, Mr. President, and members of the committee. I'm Molly Amster, and I'm the Maryland Policy Director and Baltimore Director for Jews United for Justice. I want to thank you for holding this hearing and for your support for immediate implementation of local control and trying to regain the power that we all voted for you to have. With that said, what's frustrating is that we really shouldn't be here today. We shouldn't be providing testimony in Annapolis this year. This should have all been over, but it's not. And these constant questions of what type of local control do we need, what's the structure of the department. JFJ has been working to restore local control since at least 2017, and the goal has and always is and always has been that we're able to lobby you, our elected officials here in Baltimore, easily accessible year-round, And we were never discussing what, small slice of the legislative oversight you could have. I want to also just say that the idea that that you should have that we should mimic other jurisdictions' limits to legislative power is unsubstantiated. We have asked so many times, even in the most recent document provided by the city to the Senate delegation, it does not provide a single example of language that restricts the legislative oversight of another county's legislative body in the state. It provides examples of executive powers and links to that language, but it does not provide any language about legislative oversight. The federal consent decree concerns were alleviated by Ken Thompson. I know I need to wrap up, I'm so sorry. And the consent decree documents say, as a recommendation, that this needs to happen with all deliberate speed. That was in 2018, it's 2023. And last thing I'll just say is that the CRB legislation that Ms. Themelis raised is something that we are fully opposed to as a state and local coalition. It would sunset the CRB, which is a separate agency from the rest of the city, and it would actually diminish the power and community oversight that we currently have. So thank you.
Thank you. Next up, we have Ray Kelly.
Good evening, everyone. Mr. President, Mr. Chair, and members of the council, thank you for the opportunity. My name is Ray Kelly. I'm the Executive Director of the Citizens Policing Project and a member of the Campaign for Justice, Safety, and Jobs. I also chaired the Nonpartisan Committee for Local Control, and I serve on the Local Control Advisory Board. I won't restate points already elevated today, but what I will say is I've had an active role in some capacity in every effort to gain local control of the Baltimore Police Department over the past 12 years. And the conversation to segregate the powers over the commissioner has never been part of the dialogue, but rather the simplistic thought that all the legislative authority previously administered on the state level would be passed on to the city council with the passage of Question H. This is easily accomplished by removing the restrictive language of Article 2, Section 27, as the Senate bill proposes. It's that simple. Any fabricated possible doomsday scenarios injected by the administration or the commissioner is just a creation of a political power struggle that has never existed until the possibility became a reality. I personally believe that the Baltimore's Police Department is finally on a good trajectory, and as the old adage says, if it ain't broke, don't fix it. But if the situation arises, I would also like to have the tools needed nearby, ready and able to fix the problem. God forbid there's another occurrence that forces us to rethink how we deploy our law enforcement resources or how they go about their day-to-day operation. But if that is ever the case, it must be debated and resolved in Baltimore City by our elected representatives and the Baltimore City communities. The politics and posturing around who controls who or what is premature, to say the least, and a slap in the face to the over 80,000 Baltimore City voters who voted in favor of Question H. Local control of BPD means just that. The city and its council has the authority to legislate every aspect of the department and its employees. And yes, the commissioner, day-to-day operations, and even contract negotiations if necessary. Without striking Article 2, Section 27, we continue to perpetuate a concept of self-governance of BPD and diminish all possibilities of accountability to our local representatives and consequently our residents. I can only reiterate, anything but full local control is a perversion of the democratic process and a blatant disregard for the will of Baltimore City's voters, which they'll remember in 2024 if they have to revisit this issue again with a ballot initiative. Thank you.
Thank you. Next up, we have Adina Britt.
Thank you for the hearing, but I'm kind of tired of coming down here. I was here at the last one. I just wanted to say a couple of things and then ask a question to Miss Hillary over here. This has happened before in our sister city of St. Louis.
I just want to let you know you're not allowed to ask questions.
Oh, they had their police also taken away. They were given back local control in 2002, and they're in danger of losing it again, which it's a cautionary tale to us. And also, the history of them being taken away didn't note that it was due to extreme corruption and voter suppression, where like they literally had cannons out in the street and were shooting them at people. So it was really violent, and it was just like the insurrection of January 6th. So I think that's important to have in the record. But I just want to just bring to your attention, I think that you all are forgetting about the repeal of Leobor that wasn't. Leobor is still out there as a zombie. Former sheriff, I believe, from Charles County, who was a senator, pretty much put amendments onto Jill Carter's bill 2 years ago, which reinstated a lot of the protections, and Leobor is statewide, which would override anything for the city. So I just want you all to keep that in mind, that the zombie of Leobor is still out there that needs to be addressed.
Thank you. We have a number of people joining us virtually online. Please use the raise hand function and we'll acknowledge you. I see first up we have Samantha, and you're on mute, you're off mute. Samantha, if you could unmute, you're welcome to speak. We can't hear you.
Can you hear me?
Yes, we can hear you now. You have 2 minutes.
Thank you. My name is Samantha Master. I'm a resident of the 4th District, a 4th-generation resident of Baltimore City on my mama's side, and a member of Organizing Black. I'd like to start my remarks with a rhetorical question first posed by evangelist Deborah Cox, who asked, "How did we get here? Nobody's supposed to be here." This session began with a clear mandate to return legislative authority over BPD to the Baltimore City Council. For almost a decade, organizers have been working to return control of BPD to the city so that we can engage in real, substantive, authentic accountability and oversight of an agency that has been almost surgical in its corruption, maiming, and extinguishing of Black lives, like Donnell Rochester, Freddie Gray, and Tyrone West, and so many others. We advocated for local control. Voters voted for local control. And now Mayor Scott is attempting to bungle a simple and straightforward procedural bill that would cleanly deliver local control back to our city. The goal of Senate Bill 758 and House Bill 853 is to treat the Baltimore Police Department like any other city agency. There are no similar restrictions on City Council's legislative power over other city agencies. Like the existing separation of powers prevents their intrusion into the day-to-day operations of the departments. So this amendment is as ridiculous as it is needless. The danger of the proposed amendment is that it would leave the City Council unable to legislate on anything at all related to BPD. Anything less than full local control now is an egregious subversion of democracy and a slap in the face to Baltimoreans. I urge you, please support Senate Bill 758 and House Bill 853 without amendment. Thank you.
Thank you, Samantha. Next up, we've got actually Sergio Espana. I'm sorry, Sergio, I missed you on the list.
No, thank you, Mr. Chair, President, council members. Actually, as usual, I'm going to be redundant, so I'll be brief. I'm going to butcher the words of a former president, but fool me once, shame on me, fool me twice, I forget the rest of it. But the president got it right. Like, we see through this. Like, we see through this. 83% of the electorate voted for this last November. We testified year after year to get legislation through. The council completely understands this. The mayor understands this, which is what makes it particularly frustrating and to some extent, at some point, I'm just trying to make sense of it. You're right that there isn't precedent for this, but that's also because the precedent would be to try to restrain as opposed to catch up to existing local precedent in every other jurisdiction. What I'm hearing in the proposed amendment language would be in line with what's happening in St. Louis, as was just referenced, in line with what's happening in Jackson, Mississippi. It would be us allowing the state to have the final say on the legislative oversight of a majority black city. To entertain these amendments is to entertain that concept. And the city sees through that, the electorate sees through that, the council sees through that, anyone who's been paying attention sees through that. We need basic, straightforward local control because we need basic, improved public safety efforts. Our city has proven that when residents are as closely tied to public safety efforts as possible, it works. The commissioner has just said as much. I'm being redundant here, but again, because it's important to stress, to remind ourselves of what has been said here and what's been made clear over the last several weeks. Just a couple of weeks ago, the city law department, the chair of LCAT, the city council, we're all in agreement that all that's needed is Article 2, Section 27 to be amended for there to be consistent legislative oversight with both in terms of the powers of the city and in conjunction with or a consistency with every other jurisdiction of our size or of our nature in the state and in the country. Anything else that's added to that is deliberately meant to get us to keep going around in circles. We've gone in circles by the tens of thousands for years. We want to improve our city. We want to make sure that BPD works for all of us. We want to make sure that all of us are safe. That will happen when there's local control and when the residents have a direct say through our represented elected officials at a local level. Anything else is just deliberate tricks.
Thank you. Next up, we've got Rob Farrell. Rob Farrell.
Thanks, y'all. WebEx was telling me I can't unmute myself. I appreciate y'all. Hi, my name is Rob Farrell, resident of District 6 and an organizer with Organizing Black. The issue of local control of BPD is about more than having legislative authority for a desperately needed oversight of our police department. It's about upholding democracy and whose voices are heard. Baltimore's voters have made it abundantly clear what we want by overwhelmingly passing Question H to establish local control. Any attempts to undermine complete democratic local control of BPD disenfranchises Black and brown voters. The mayor and the administration are just delaying and obfuscating. It should be very clear after this 2-hour session that this is the goal, and this was the goal from the outset. They want to limit the city's ability to control the police commissioner so that the police can continue policing themselves. All this talk about not violating the consent decree, but police policing themselves is how we got in the consent decree to begin with. I'd like to remind everyone that a key pillar of the mayor's campaign was transparency and accountability to restore trust in our city government. Our government, quote, I quote, our government works best when it works in the open and out of the shadows. I will take measures to ensure that the legislative process is more transparent and accessible to Baltimoreans, end quote. How exactly has any of this process been transparent or accountable to the people? Someone please tell me how further limiting the City Council's power to legislate BPD accomplishes this. Baltimoreans voted for the City Council to have full legislative power over BPD, full stop. The proposed amendment is unacceptable. It unjustly limits representative democracy and police accountability in a majority Black city. Thank you all for your time.
Thank you, Rob. Next up, we have Alan.
Can you hear me?
Yes, you've got 2 minutes.
Okay. Fantastic. Thanks so much, Chair Conway and council members, for the opportunity to speak tonight. My name is Alan Liu. I'm a policy counsel at the NAACP Legal Defense Fund. Local control should not be controversial. Marylanders in every jurisdiction throughout the state, through their city councils, should have the power to pass ordinances reflective of and responsive to the priorities and needs of their respective jurisdictions. A few questions now remain before the General Assembly that I hope to answer with clarity. The first is, does the Baltimore City Council currently have authority to pass ordinance regulating BPD? I think that question has been answered tonight, so I'll skip that. The second question I think is more important, which is, should the Baltimore City Council be constrained in its legislative oversight? The answer clearly is no, it should not be constrained. And that's the case for 3 reasons. The first is that overwhelmingly, Baltimore voters voted to pass question H. It says that BPD should be returned to the city as a city agency, and we should not turn our backs on the mandate of Baltimore voters. Secondly, no other city or county council is limited in its legislative authority in this way by the General Assembly. There's no other place in Maryland like this. Montgomery County Council can legislate over Montgomery County Montgomery County PD. The same is the case for Baltimore County Council and Prince George's County Council, Howard County Council, Frederick City Board of Aldermen, Gaithersburg City Council, Rockville City Council. All of these places have authority to legislate their police departments without constraint by the General Assembly. It would make Baltimore different, and Baltimore should not be different. Third, Baltimore City has the largest Black population of any jurisdiction in Maryland, both by number and percentage. Baltimore City, a majority Black city, must not be treated differently than any other place in Maryland. Baltimore's Black voters must not be disenfranchised. And the third question is, how quickly should this come about? I'd argue immediately. There should be no reason why there's a delay in this council having authority to legislate over BPD. Thanks so much for your keen attention to this matter. That's so important to all Baltimoreans.
Thank you, Alan. And the last person we have signed up is Namita. Namita? You're unmuted now. Your connection's really bad.
Sorry, can you hear me now?
Yes, we can. You've got 2 minutes.
Okay. Local control is political autonomy and democratic. City council should have the right to exercise legislative power over investigative strategies in BPD because BPD has proven itself unable to be accountable time and time again. This amendment is anti-Black and anti-democratic. The bill should be passed without amendments. Thank you.
Thank you, Namita. All right, any other further testimony? Seeing none, I want to thank everybody for coming out tonight. I want to thank the administration for taking the time to walk us through the proposed amendment. And I want to thank the council for bearing with the wonky conversation. I hope we all learned a little bit about law. With that, this hearing is in recess. Thank you.